Earlier today, I read the Supreme Court's opinion in the case of, the Colorado's lawsuit to keep Donald Trump off the ballot. And it's a short case. If you haven't read it, I recommend you do. The per curiam opinion is maybe, I think, 12 or 13 pages long. It's relatively brief. I have not had time today to see what other folks are saying about this case, and I wanted to offer to you a few thoughts about why I think even the progressive justices on the Supreme Court, I'm referring to people like Justice Jackson, Kagan, Sotomayor, why even they were unwilling to go along with Colorado's argument and keep Trump off the ballot. I think the first case, the first reason why is relatively straightforward. Nobody on the Supreme Court, nobody, no conservative justice, no progressive justice, nobody wanted to go down in history as part of a crew that used the government's monopoly on legalized power to target an opponent, a political opponent to the current incumbent administration, and to keep that opponent off the ballots, to keep that opponent from running for office. Nobody wanted to be known for the rest of history as that person, and I get it. I wouldn't want to be known as that person either. There's also a second, I think, deeper reason, and it has to do with the 14th Amendment. Those progressive justices, now they are acutely aware that there have been a few constitutional provisions that have been used repeatedly and expansively to justify, to authorize, to excuse the enormous growth in the administrative state, the federal government, at the expense of states over really the last century. The Commerce Clause, of course, immediately comes to mind. But here in this case, I'm talking about the 14th Amendment. The 14th Amendment has ushered in a new kind of civil rights regime that really has very little to do with civil rights. Civil rights are rights created and protected by law within civil society that provide the ways for citizens to participate in the civil governance of civil society. Things like voting, that's a civil right. We need laws saying when is the election going to be, and where the ballot's going to be, what are they going to look like, and how, all of that. The right to run for and hold certain elected offices, those are civil rights. The right to be judged by a jury of your peers, your fellow citizens, if the government accuses you of violating various criminal laws, that's a civil right. But what the civil rights regime that really has been justified by the 14th Amendment now extends to all kinds of things people want, people demand, that really have nothing to do with civil rights. Things like getting a job at a place you want a job at. People now call that a civil right, and they say that should be protected. It is protected by federal law and regulations. Getting a certain minimum wage at that job. Americans now say that's a civil right. Being able to shop at a particular store and buy something, or make someone at a store, at a business, provide some kind of service for you that maybe that business owner doesn't even want to do, doesn't agree with. We now call all those things civil rights. The right to various subsidies and welfare, those are now under the umbrella of the civil rights. And ultimately, all of that, the modern regulatory subsidy state has, to a large extent, been justified by the 14th Amendment. Now, I just want to contrast very quick. I want to give you a sense here of how far off the mark this is. I'm going to read to you one of the key passages. This is the 14th Amendment. The 14th Amendment says, this is the first sentence, of course, is about citizenship for people who are born here and subject to the jurisdiction, written, of course, to make sure that newly freed slaves after the Civil War would be treated as citizens. And then the next operative sentence, the second sentence of the 14th Amendment, demonstrates how focused they were on the problem of states. It says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state, again, addressed at states, deprive any person of life, liberty, or property without due process of law. No state shall deny to any person in its jurisdiction the equal protection of the laws. You see how the 14th Amendment is addressed to states. The whole idea, I'm going to paint with a very broad brush here, and I think this is true. The whole purpose of the 14th Amendment was to say to states, be decent, be morally and politically decent. Don't restrict things like voting and criminal protection and protection of private property. Don't restrict that based on skin color and ridiculous secondary arbitrary qualities like that. Make sure that you offer equal protection to everybody. All the citizens within your state should be free to vote if they want to vote. They should be secure in their property. They should be secure in their person. They should be secure from, criminal violations of their right. That's the thrust. But now what has happened in the last 6 decades is the 14th Amendment has been used to expand the power of the national government in a host of ways, creating agencies like the EEOC to enforce laws like the 1964 Civil Rights Act that I would argue really has very little to do with civil rights. Things like Title II of the Civil Rights Act is all about public accommodations. That's a business. These are privately owned businesses. Remember, we just read from the 14th Amendment, which is all about states. No state shall. It doesn't say anything about privately owned businesses, but we get a 1964 Civil Rights Act that says privately owned businesses, we're going to tell you who you may and may not engage in trades and commercial exchanges with. Title VII has to do with people offering jobs in their own businesses that they own, offering jobs to whom they want to offer, saying, no, you're going to offer jobs to the people we tell you you're going to offer. And this gives rise to big federal bureaucracies that employ thousands of bureaucrats, all of whom, of course, are not only unelected, they're unionized. And so they act as money laundering mechanism. That, their taxpayer salaries, a portion of it goes to the unions, which then, of course, go to the coffers of progressive Democratic candidates. So here's my point. The 14th Amendment has been used to eclipse the power of state governments with a big, expansive federal administrative state, a big federal subsidy state, regulatory state. And progressives like Sotomayor, like Justice Jackson, like Justice Kagan, they know this. They very well understand this. They know the case law. They know these arguments that have been made in the Supreme Court. And I think not for 1 second are they going to allow the 14th Amendment to be, in their minds, turned upside down and used to empower states at the expense of the federal government. For them, this ratchet only goes one way: more and more and more power toward the federal government, less and less power to the state government. And what Colorado was asking, yes, it involved Trump, who progressives hate, and even a lot of non-progressives hate. But the bigger picture here, Colorado was asking that the state of Colorado, the state government of Colorado, be able to take some decisive, independent action, independent of the federal government. And I think those progressives looked at that and said, no way. We are not allowing state authority, state power to start to expand in any way. We only expand the power of the federal government. I think that is a big part of the reason why even the progressives on the Supreme Court refuse to go along with the argument of the state of Colorado. Let me know your thoughts. I'd love to hear them. Thank you.